Hello, this is the Grouchy Historian. Welcome back to AP US Government. We're at our last unit, Civil Rights and Civil Liberties. So this is a very full unit, lots of material here. So we're going to try to get through the highlights here. But going through the review guide here, basically the institutions of government and civil rights and civil liberties to me look like the most challenging sections of the review process. This is where you are going to encounter your Supreme Court case question on the exam. So let's kind of step through this and see what we got. Okay, so again, we have certain rights as American citizen, and AP offers two specific definitions here that you need to keep in mind, right? AP defines civil liberties as those protections enjoyed by all Americans from the abuse of government power, and defines civil rights as specific protections from discrimination based on race, gender, or other minorities' status. Okay? Important definitions straight out of the study guide. I'm sure they'll be straight out of your book. And again, this is where you will discuss a Supreme Court case, most likely a compare and contrast sort of case between the cases that are mentioned here and the ones that and an example one that they may pull on the test, right? Okay, so let's get right to it. Most of the cases that are discussed here, other than a couple of the sort of major precedent-setting cases like Marbury versus Madison or McCulloch versus Maryland, have to do with the Bill of Rights and how the Bill of Rights apply to Americans in a lot of daily situations, right? And one of the most important things is that the Bill of Rights applies to both the state and the federal government. This, of course, is a court case that determine this, right? So the First and Second Amendments are probably the most argued about amendments through history, right? The First Amendment is the right of freedom of speech, freedom of the press, freedom to petition the government for grievances, freedom of assembly, and freedom of religion. So there's a lot under there, that First Amendment, and that's probably the most argued amendment throughout history. Second Amendment is pretty close behind. This is the one with the right to keep and bear arms, right? So you will never find an amendment that has been argued about so much in court because of a comma. Yes, a comma. Read about it. Other amendments that are often argued are the Fourth Amendment, which is the right of unlawful searches, right? So you have amendments to court cases related to the rights of the accused in criminal cases and civil cases occasionally, lawful searches, trial by jury. And of course, recently we've established, or the Supreme Court has established, a nebulous, and that's my word, not the books, but a nebulous right to privacy. Now, you could argue that, you have the rights of unlawful searches, rights of the accused, a right against self-incrimination. But beginning with, of course, Roe versus Wade, they have invented, in my opinion, this and other legal scholars, this sort of nebulous notion of right to privacy without really defining what privacy means particularly well. Okay. And of course, there could be other civil rights cases and discussions related to these other amendments, right? So I'm just going to put these here. These are, again, straight out of the study guide. Marbury versus Madison, McCulloch versus Maryland, probably two of the most important Supreme Court cases in our country. Interestingly enough, an interesting contrast is looking at, and they don't list it here, but one of the things that personally kind of drives me nuts is this notion of precedent, right? The Supreme Court, our entire legal system, the English common law legal system, is built on the notion of precedents, right? So what legal ruling came before on this particular topic? Do we need to tweak it? Do we need to, further define it? So one of the things that has kind of drives me nuts is when people say, well, Roe versus Wade has a lot of precedent behind it, so we can never overturn Roe versus Wade because there's so much precedent. As I think I mentioned in another video, a particular senator said it has a super duper precedent. Like, I'm not really sure where you find that in a law book, but apparently that's what he uses. I would submit that that's a fallacy. That's crazy. Now, you could take a Supreme Court case like the Dred Scott decision, right? That was the law of the land in 1854. Unfortunately, we had to have a civil war and an amendment to the Constitution, in fact, 3 amendments, the 13th, 14th, and 15th, to effectively overturn the ruling of Dred Scott. A more recent example, in 1896, I believe it was, you had Plessy versus Ferguson, which established the notion of separate but equal, right? That's how you could have separate facilities for whites and not whites, colored as they were termed back then. And if you've ever seen some old pictures, you would literally see 2 water fountains in a public place. One says whites only, one says colored only. That was part of Plessy versus Ferguson. And of course, everything was segregated, particularly in the South, in the early part of the 20th century. Schools, colleges, public facilities, that was the law of the land. Then, of course, along came Brown versus Board of Education, which completely overturned the precedent of Plessy versus Ferguson and said, no, that is unconstitutional. That is discriminatory based on the 14th Amendment, that you would have separate facilities, educational systems, schools in this case, for whites and not whites. So you probably won't discuss that concept in your class because that would make, your instructor's head probably spin. But Roe versus Wade is not inviolate. It is not have so much precedent that it couldn't be overturned. It's just a matter of finding a particular case to overturn it. That is my pontification for the day. But most Supreme Court cases, if you look at them and you read through them, they usually will not completely overturn a precedent. They may define it, they may tweak it a little bit, but they typically will not completely do away with it, okay? But there are a number of cases. This is one of the reasons in particular I recommend you buy a study guide. No, I don't make a fee for each of these. I just think they're particularly useful. Again, in addition to the practice test, which I highly recommend, you also get a lot of online resources with them that can help you. They have extensive downloadable key terms lists, which I highly recommend. I didn't put them here because, of course, they're copyrighted material. Most importantly, the guide here goes through each of the cases listed here, like McDonald versus Chicago, United States versus Lopez, Gideon versus Wainwright, okay? Goes through all of these cases and talks about the issue, what the ruling was, and more importantly, it kind of lists other cases that are related to it. So it's an excellent resource. This is a lot of Supreme Court cases to become familiar with. And I highly recommend having one of these to help you through that. Again, this is probably going to be an extremely challenging part of the exam because you don't have a lot of room to write. Again, you have to very quickly state the case, state the ruling, state the importance, and then very likely state how it relates to the case that you're dealing with, okay? So I recommend that you get the study guide, go through each of these cases, and make sure that you have a good understanding of the basic impact on America, society, government of these particular cases. Okay, this is pretty much the end of the course here. Hopefully you found it useful. If you have any questions, comments, put them in the comments section under the video. I will try to get to them. I ask that you put them there because chances are somebody else may have that same exact question, so we can share some knowledge and, if need be, get a little discussion going. So thank you very much for watching. I hope you found them useful.